Good day, Crime Talk aficionados. We have a Bryan Kohberger update. KarenRead gets ready for a documentary about preparing for her trial. Is the Luigi Mangone sex tape real? The Los Angeles District Attorney tells the Menendez brothers, don't pack up your belongings just yet. There is no legal defense based upon someone's legal status. A juvenile detention fight club, this day in legal history, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that bell for notifications, and yes, you can check us out on any of your favorite podcasting apps as well. Also, go to crimetalksearch.com, sign up for that background subscription service today, where when you have that service, you can do as many background searches as you desire. And you literally have a background search prepared while you wait. It is emailed to you, and you can even get updates later if new information comes about. It is rather simple. You're going to get that report, and it's going to show what is the person's online profile like, emails associated with this person, phone numbers associated with this person. You're going to find out if they have criminal history. Do they have liens? Do they have judgments? Do they have to register on one of those public registries? Yes, go to crimetalksearch.com. You're going to be happy that you did. All right, let's go ahead and get to the docket for Monday, March 10th. That's right, the second day of daylight savings. Ugh, those first few days of daylight savings just suck. I'm telling you, let's just pick a time and stick with it. I like the sun in the evenings, but let's stick to it. Not when my body gets used to the old way, then I got to change it. Let's not do that. All right, let's go ahead and get to the docket. First, a Bryan Kohberger update. Yes, I love the fact that the court is releasing things in the Kohberger matter. And sometimes it's almost kind of trivial, but it's things that need to be done through the court system. And now we're getting to see what's going on. Now, first, the district attorney filed a motion to modify the no contact order, which you think is fine. Well, no big deal, right? The state of Idaho, through their prosecuting attorney, moves this court for a modification of the no contact order previously filed herein, prohibiting the defendant from having any contact with the father of one of the victims. Now, I doubt that he would have contact with any of the victims since he's in custody. And that's pretty standard. In most states, it's a mandatory protection order anytime there is a criminal case that goes into effect. But here, this motion is based on the fact that the father has requested the addition of his wife and stepdaughter to the no contact order. The state has contacted the defendant's attorney, and they have no objection. Now, I think it's weird, though, they want to modify the contact order without stating which one it was. I'm sure we could figure out which family member it was. But the reality of it is, it doesn't matter. But kind of trivial, right? Like, why now? This case has gone on since November of 2022, and now we're getting around to protection orders. Next, we have another motion filed by the defense saying, hey, Mr. Prosecutor, you haven't turned over relevant information. Comes now. Bryan Kohberger, by and through his attorneys, and pursuant to the applicable rules, filed the defendant's 22nd supplemental request for discovery. Each of the requested items are still outstanding, and they are outlined in the attached 7th motion to compel, Exhibit A, filed under seal. Anyway, they request that these matters be set for an oral argument. Then we have the defendant's motions for leave to file response to the state's amended expert disclosures. This is interesting. I'm not really sure. Usually what happens is the prosecution or the defense, doesn't really matter, files their notice of expert witnesses. And the expert witness has to provide a report. They have to say what they're going to opine about, why they have some specialized training or knowledge, and how they came to that conclusion. It's pretty simple. You don't have to be a scientist. You don't have to have a fancy PhD to be an expert. It's just anybody who has some sort of specialized training and knowledge that basically maybe everyday individuals may not have. All right. It's kind of a very low standard. But, if I had a case and say, for example, you wanted to sue somebody because you had a mechanic work on your car, they didn't put it back together correctly, and the engine died. You could bring in the other mechanic who fixed it and have him testify as an expert, as his training, knowledge, and experience, specialized knowledge, and he could be qualified as an expert. So it's just anybody with some sort of specialized knowledge. All right. And anyway, the motion by the defense says that the hereby moves this court for leave from the court's sealed order governing further criminal proceedings and notice of trial setting filed January 9th, 2024. Defense counsel is asking for leave to file a response to the state's amended supplement response to request for discovery regarding expert testimony filed with the court on March 3rd, 2025. They say that Mr. Kohberger requests leave to provide responses to the state's amended disclosure to the extent the disclosure presents new or changed expert opinions. Mr. Kohberger requests leave to amend or file additional motions in limine regarding these disclosures, and Mr. Kohberger grounds these requests in his rights protected under the United States Constitution, effective assistance of counsel, right to confrontation. And they state that these disclosures were made 2 months after the state's expert disclosure deadline and over a month after the state has the benefit of Mr. Kohberger's expert disclosures. Further disclosure did not come until 2 weeks after the state rebuttal expert disclosures. So now it's basically a fight of, why are you changing your opinions now that you have our opinions? Well, that's the way it goes. Let's just say prosecution produces their expert report. Defense says, here's our expert report, and these are the conclusions we came to. And then the expert on the other side can look at it and say, yeah, I either agree or I disagree, but I'm going to put it in my report so I can testify to it. And so there you go. The battle continues, and the order sealing the defendant's seventh motion to compel. It goes on and on and on, ladies and gentlemen. It's litigation. Litigation is a black hole. There's always something else that can be done. There's always something that can be fought over. And I'm telling you, only people that enjoy this stuff are the people watching in the seats in the arena, so to speak, and the attorneys. But if you're involved in it, it's stressful, it's expensive, and the only ones that really benefit from it are the attorneys. I know you're telling you the way it is, ladies and gentlemen. Lots of times I've told people, do not litigate on principle. Resolve this case. It's simple, just the way it is. All right. Next on the docket, KarenRead. So the director of the documentary on the KarenRead case, Monday stated that he had unprecedented access, and his film crew did as well, to the former financial analyst and her high-powered legal team during the buildup to KarenRead's first trial for allegedly killing her boyfriend in a drunken driving case, right? Anyway, it's a follow documentary. The director says Dunn Muir, who helmed A Body in the Snow, the trial of KarenRead. It's a 3-part series premiering March 17th. So get ready, I guess. And anyway, following someone throughout their trial is very unusual. The director noted, he says the access is unprecedented and that we had Karen and her defense team. It was a little surprising and a great opportunity to be able to them to go through the process. Anyway, they also noted it's very unusual for somebody to have access to the defense team so they think they have something important for everybody to share. Anyway, this 3-part series is set to air on the Investigation Discovery Network on March 17th, 18th, and 19th. It'll also stream on Max. I'm always a little uncertain about this. And full disclosure, I had something like this done years and years ago. It was a child abuse resulting in death case, and it was something called In the Jury Room. But everybody got permission. The producers, it was done by ABC, followed the prosecution. They followed the defense. And in that particular case, they actually videotaped the jury deliberation process. We got the approval from the Colorado Supreme Court. I believe they did it in at least one other state as well. But once again, you had approval from the Colorado or the Supreme Court in that particular state. So, talking to the press, though, always makes me uneasy. And my biggest thought during that process was like I said, it was a bad case. Child abuse resulting in death. My client was found guilty of a misdemeanor. It worked out well for my client. But had we lost, I could see the post-conviction matters. Oh, the attorney was just showboating. He's revealing attorney-client privileges. I mean, anything you could possibly come up with if it doesn't go well. And here, the client, anything she says will be used against her. So if she says something in that video that is maybe contradictory or an admission about her involvement in that particular case, obviously, it could be really, really bad. I think it's better just not to do things like that. And having done that, I think it's better. Looking back, hindsight, 20 years later, it's probably just better. Anyway, the judge presiding over the KarenRead case on Friday denied the defense request to add a fifth lawyer to the KarenRead defense team. In a brief ruling, the judge said Read's lawyers cannot add New York attorney Mark Betterow to their ranks. The judge denied the request in part because Betterow also represents Aidan Kearney, the blogger known as Turtle Boy, who's charged with harassing and intimidating witnesses in the KarenRead case. The judge said that amounts to a conflict of interest, and that is not waivable under the state attorney rules. I totally agree. In seeking to add Mr. Betterow to Read's defense, Read's attorneys David Yannetti said in an affidavit that Betterow promises to restrict his use of certain information, and the judge says, no, you can't do that. It's very hard to build what they refer to as a Chinese wall around an attorney and say, you can be on the case, but you're not going to get this information. And then don't use that information, what you learn here, in your case. Doesn't really work. Very hard to do. Just not worth the problem. Anyway, the clear inference of the promise is that Mr. Betterow would not use protected information gained in the representation of one client for the purpose of representation of the other client, the judge noted in her order. He thus proposes to ignore information known to him through his representation of one client, even where the information might benefit the second client. That's untenable, the judge noted. The court cannot permit such a conflicted representation and declines to add the defense team that currently numbers at least 4 lawyers. Now, obviously, Ms. Read has pled not guilty to the charge of second-degree murder, manslaughter, while operating under the influence and leaving the scene of a crash resulting in death. Now, prosecutors allege that she backed her Lexus SUV in a drunken rage into her boyfriend, Boston police officer John O'Keefe, early morning hours of January 29, 2022, after dropping him off outside a Canton home, followed by a night of bar hopping. Her lawyers say that she was framed and that O'Keefe entered the house owned by, at the time, a fellow Boston police officer, where he was fatally beaten and possibly attacked by a German Shepherd before his body was planted on the front lawn. Now, Read's trial is scheduled to begin on April 1st after the first trial resulted in a mistrial back in July of 2024. Now, Mr. Kearney, Turtle Boy, has aggressively championed Miss Read's innocence and helped spark the national interest in her case. His lawyers say his actions that authorities are calling criminal harassment were legitimate acts of investigative journalism and advocacy protected under the First Amendment. Now, back in January 2024, authorities alleged that Miss Read had been orchestrating Mr. Kearney's coverage and sharing non-public information about her case with him. And records indicate that Kearney and Read had 189 phone calls over 7 months back in 2023. The judge issued another order that limits what lawyers in the case can say about the matter when they're outside of the courtroom. The gag order issued last week was requested by prosecutors who have accused Read's defense team of violating the protective orders and court's rules. Now, the decision by the judge instructs lawyers on both sides not to release information that could potentially prejudice the legal process or influence the trial's outcome, according to the order. Standard kind of rules when it comes to attorneys. Now, like I said, I think the court can limit the attorneys from saying things that are going to dissuade or prejudice a particular side in the case. But I think we, as the public, should be able to get the information and make our own decisions about it. The judge's restrictions cover information that is protected by court orders or could prejudice potential jurors or witnesses, and the lawyers are also prohibited from publicly disclosing evidence that is unlikely to be admitted at trial. Seems fair. Go try this case in the courtroom. Okay. Now, over the weekend, I was able to take a little bit of time off, and I went deep into a lot of bloggers and other people, say, for example, on X and things of that nature. There are definitely two camps out there. KarenRead has been framed. She's completely innocent. And then obviously KarenRead is guilty camp. I think most of the people there are absolutely reasonable. Okay. And like I said, the first trial, I probably would have said not guilty. It was just weird the way the whole trial came about. I don't think the prosecutors were particularly great. And I think there was some reasonable doubt, obviously evidenced by the fact that it was a hung jury and they couldn't ultimately reach a decision. Now, I understand the whole, did they meet your decision? No, it doesn't matter until it's officially out there. All right. But let me just be realistic. And some people are going to say, oh, Scott, you're falling into one particular camp. You're not. Let's have the trial. Okay. And I know, okay, everybody loves a good conspiracy, but like lots of things in life, it doesn't matter what you think or what you believe. It only matters what you can prove. And that really what it comes down in court. And I watched all the video this weekend of, was the taillight broken when the car goes to the impound? It looks like it was broken. And we also had the juror from the previous case that said, well, we really didn't see the whole conspiracy to frame her thing. I think that's a little bit of a stretch. And don't get me wrong, I've had lots of cases where I thought, man, this is going to be great. These cops did this and they did that. It's tough really to prove. And generally, most people hold police officers in general high regard. So, and second time around, I keep telling you this, ladies and gentlemen, second time around is not doing KarenRead any favors. The defense had their shot. The prosecution is fixing their case. They have a much more competent prosecutor, former or defense attorney, back to prosecutor, going after this case. We're going to have to wait and see. I'll give everybody the presumption of innocence. We're going to have to wait and see. But I am a realist, ladies and gentlemen, and any good defense attorney that's going to be intellectually honest is always looking at the facts of the case. And I've had cases that I thought this is going to be a great case. And then we learn some new facts and the case turns to absolute garbage. And that's the way you have to be. You can't ignore the bad facts. You learn that in debate, you learn that in law school, and you certainly lose that in trial. If you can't either embrace or explain the bad facts, it's going to get ugly and the defendant's going to crash and burn, and it's not going to be pretty. Next on the docket, is the Luigi Mangone sex tape real? Well, the alleged CEO killer, Luigi Mangone, through his attorney, say he is not the young man seen on the bathroom's text tape being offered for $500,000. That's right, $500,000 on the deep web, ladies and gentlemen, and you could own the Luigi Mangone sex tape. Is it real, though? Is it really worth it? Anyway, hopefully everyone realizes these are fake and not Luigi, says his attorneys. Now, this comes after a sex tape broker, a guy by the name of Kevin Blatt, told the U.S. Sun he had seen a sex video featuring Mangone in his parents' bathroom. Mr. Blatt claimed the alleged killer made the video for a Grindr user who was now trying to sell it for $500,000. Now, Blatt even shared blurry screenshots that he claims show that the shirtless Mangone is the one performing on the Grindr, or performing for the Grindr user. Mr. Blatt said, the video I have seen is not high production stuff. It's pretty seedy solo stuff that looks like he's recording it in the bathroom at his parents' house and in a bedroom, and then sent it to a man he met on Grindr. Now, Mr. Blatt said that Mangone was using an alias on the hookup app and met at least one man on it. But the phone number the videos were sent from has a Maryland area code, which is where Mr. Mangone was from, and you can actually match up his parents' bathroom from real estate listing photos of the house. And it is undoubtedly him. When the man saw that Luigi had been arrested, he couldn't believe that that was the same guy that he met on the Grindr app. However, Mr. Blatt has also said that no one has shown interest in buying the tape because, well, most people were like, I don't want to touch anything that has to do with murder. And he doesn't want to support someone accused of murder. Now, Mr. Blatt added, it's the same reason why he doesn't want to broker this thing I want nothing to do with it. Okay. Anyway, Mangone's denial regarding the sex tape comes as the Radar Online article claimed he made upwards of 20 highly stylized sex tapes before he was arrested on charges of killing the healthcare CEO Bryan Thompson in New York City. In the weeks that follow his arrest, key details about Mangone's sex life and health battles were made public. He's even posted on his X page about having a pretty huge, anyway, in response to a post asking if anyone on the platform had a PhD, a public high school diploma. Anyway, it's also emerged that he had suffered a back injury so severe he was unable to actually have sex, according to his former roommate, a guy by the name of R.J. Martin, who had lived with the murder suspect for 6 months in Hawaii in a co-living space. And he has stated that to New York Times that he lived in agony. Anyway, Mangone has pled not guilty to multiple counts of murder, including murder as an act of terrorism and a bunch of other crimes, obviously in both state court in Pennsylvania, New York, as well as federal charges in the District of New York, which will give him the presumption of innocence for. The killing of Thompson as he walked to an investor conference obviously was not good or justified and sent shockwaves through the corporate world, rattling executives who say they saw a spike in threats. Mangone has attracted quite a following as a stand-in for frustrations over coverage denials and hefty medical bills. At the time of his arrest, Mr. Mangone had been on the run for 5 days. Police confirmed he was carrying a handwritten manifesto in which he rallied against United Healthcare. The 262-word document, he criticized corporations for abusing our country for imminent profit while failing to improve the life expectancy of Americans. Mangone, who comes from a wealthy family, is the grandson of a self-made millionaire who owned luxury resorts, nursing homes, and even radio stations. He attended the prestigious Gilman School in Baltimore, which was a paltry $40,000 a year, where he graduated as valedictorian. He obviously also went on and graduated from the Ivy League School, University of Pennsylvania as well. And guess who wants to get their name in on this as well? Gypsy Rose. That's right. Also known as Gypsy Rose Blanchard. She offered some frank advice amidst all the fanfare surrounding Luigi Mangone, obviously for his charges. Drawing from her own notoriety, she stated that she realizes that there are individuals with less than pure motives, and there are lots of strange people out there, when she was giving her comments about the Luigi Mangone case. And she said specifically that you have to be very careful as to what you do with the people that contact you. She said that you need to appreciate the support, ignore the critics, and focus on doing your time. Very interesting. Like I said, there are lots of people that try to befriend people in prison all the time. I've seen it. People have asked me to do it. If somebody wants to talk to me, but I'm not going to try and befriend them, saying, "Hey, I'll be your pal," but in exchange for that, come on my podcast or something along those lines. And we've had lots of people where we could have really done that. One of the first cases that we covered could have really exploited that, but it would have been, in my opinion, unethical and sleazy to do so. Next, the Menendez brothers are told, don't pack your cell up just yet. That's right. Lyle and Eric Menendez have been serving sentences of life in prison without the possibility of parole for the August 1989 murder of their parents, Jose and Kitty Menendez, who were shot in the family's Beverly Hill home. Now, the teens at the time admitted to the killings, claiming fear and self-defense after a lifetime of physical, emotional, and sexual abuse suffered at the hands of the parents. Then in 1996, a jury convicted them of first-degree murder. They have both spent over 35 years in prison. Well, the Los Angeles County District Attorney Nathan Hochman announced today that his office is prepared to go forward with the court's initiated resentencing hearing in the Menendez brothers' cases. And at a news conference, Hochman said he is asking the court to withdraw former DA George Gascon's prior resentencing motion. He says the basis for that request is that the prior motion did not examine or consider whether Menendez brothers have exhibited full insight and taken complete responsibility for their crimes by continuing for the past 30 years to lie, the DA said. During the news conference, Hochman listed several examples of lies the brothers have never admitted to telling. According to the court documents, Hochman cited the Sirhan case in which Governor Gavin Newsom denied parole to Sirhan, the murderer of Robert F. Kennedy. And Hochman said that even though the parole board had recommended parole based on the fact that Sirhan had spent at least 50 years behind bars, was in his late 70s, and had troubled as a youth with violence, Hochman said in that case, Newsom determined Sirhan posed an unreasonable risk of danger to the community. And Hochman told the reporters at the news conference that the brothers have failed to show that they are no longer a danger to the public. His position is that the brothers should not be released from prison. You don't see that very often in California, do you, ladies and gentlemen? This Mr. Hochman, a little smarter guy than that Gascon, for sure. Anyway, he emphasized that the court's decision to resentence is profound, since they could potentially be changing a life sentence without the possibility of parole. But he said the sentence has previously been upheld by 5 different appellate courts. Last month, Hochman opposed a new trial, asking a judge to deny the brothers' habeas petition requesting and vacating their convictions and ordering a new trial. The habeas petition, filed in May of 2023, cited what lawyers describe as 2 new pieces of evidence backing the brothers' allegations of abuse, including a 1988 letter written by Eric Menendez, which alludes to sexual abuse by his father. Now, Governor Newsom has ordered the state parole board to conduct a risk assessment of the brothers to determine whether they pose a risk to public safety. Now, Hochman said earlier that the credibility of the alleged new evidence has been called into question since he said the brothers lied throughout the investigation. He also said that the question of whether they were sexually abused is not a determinant of whether they are guilty of murder. The jury was not asked to decide if the Menendez brothers were sexually abused by their father, and their mother failed to stop it. Only if the Menendez brothers committed these murders willfully, deliberately, and with the premeditation or in self-defense. The petition by the prosecutor notes, asking for them to denied. Anyway, the hearing is scheduled to take place on March 20th and 21st. Several family members for the Menendez brothers have criticized Hochman's trial opposition. Well, there you go, ladies and gentlemen. The Menendez brothers may not be getting out of prison. I mean, it was cold-blooded murder. You know, think of old Gypsy Rose. Even if you think somebody's abusing you, you can't then go kill somebody after the fact. The act has to be taking place when the alleged self-defense takes place. That's been the law forever. I don't know. I think it's frivolous. I get it. They get all their fame. Everybody followed it. I remember this case back in college and law school. You know, one of the things about criminal law is sometimes you have to get to the point where there's finality. You've exhausted all your appeals. You've exhausted everything you can do. And here we are 35 years later, ladies and gentlemen, and we're still litigating over the case. The only thing that should be taking place at this point is clemency from the governor. Should they have their sentence commuted so that they can get, parole eligible? That's the purpose of clemency. Certainly don't deserve a pardon. And I kind of agree with the district attorney. These two are manipulative little people. They were back then. Maybe they've changed. I don't know. But you think maybe they'd come out with a little more, hey, thank you. Maybe we didn't tell the whole truth all the way. I don't know. And if you did think you told the truth, then don't apologize at all. There you go. Next, one's legal status in the country is not a defense to murder. That's right. Authorities in Texas arrested a man who they say killed his fiance after he asked Google, "Can I kill an illegal human?" because the victim was reportedly an undocumented immigrant. So Ty Vaughn is charged with murder back in the January death of Luis Baños Norberto. Now, Vaughn is accused of shooting Norberto in the face and then moving his body in an attempt to make it look like a suicide, according to the arrest affidavit. Now, this all happened on January 14th at an apartment complex near Houston. According to the arrest affidavit, where they charged Mr. Vaughn, he claimed he came home shortly after 5:30 a.m. to find Norberto dead. But surveillance video and interviews with neighbors told a different story. Video showed that Vaughn actually returned home shortly after 4 a.m. Neighbors reported hearing a gunshot a few minutes later. Around 4:30 a.m., as Norberto lay dead in his apartment, Vaughn allegedly texts the victim, Babe, why are you not texting back? The cops reportedly said Vaughn waited until at least 5:30 a.m., some 90 minutes after the murder, to call 911. He said, my spouse is dead. He allegedly told dispatchers, help, my life is over. Officers found Norberto's body lying on a bed with a lever-action rifle up against his arm and a ripped up picture of him and Vaughn nearby. The old jilted lover suicide murder plot. Anyway, detectives noted Vaughn kept saying that Norberto was an undocumented immigrant. When they searched his phone, they allegedly uncovered a search. Can I kill an illegal human? That's what he searched on Google, ladies and gentlemen. Anyway, Mr. Vaughn spoke with the news before his arrest. He told the TV station there that the police know all the details. When offered condolences, he allegedly replied, I mean it. It is what it is. Police arrested Mr. Vaughn Saturday. He is at the Harris County Jail on a $500,000 bond. He has court scheduled for later this week. Next, one way I've always said juvenile detention facilities is simply a way to turn young criminals into much more sophisticated adult criminals. And it doesn't help when you have staff that is basically allowing a fight club to take place in the juvenile detention facility. So in California, 30 officers at the Southern California Juvenile Detention Facility have been charged for their role in the facilitation of so-called gladiator fights between youth in the care of the facility, according to the charges brought by the state attorney general. Now, a grand jury indictment alleges the officers at the Los Padrinos Juvenile Hall in Los Angeles County allowed and sometimes encouraged nearly 70 fights to take place between July of 2023 and December 2023. More than 140 victims between the ages of 12 and 18 were involved. 22 of the officers were scheduled to be arraigned on March 3rd at the Los Angeles County Superior Court. Now, the investigation began after the Los Angeles Times first obtained and published footage that shows a 17-year-old boy being attacked by at least 6 other young men who come at him one by one as officers stand by watching. Some officers appeared to laugh and shake hands with the participants in the beating. The video was first made public during a court hearing during which the 17-year-old public defenders argued to a judge that he was not safe at the Los Padrinos facility and he should be released on bond pending the trial. Now, the indictment singles out 2 probation officers who allegedly told staff members ahead of time that fights would occur and they were not to say anything, not to write anything down, just watch. It also alleged one of the officers told youths involved to refuse treatment when they went to a medical to get treated by the nurse. Now, the Los Angeles County Probation Department, which runs the facility, said in a statement that it fully supports and applauds the Attorney General's office for the indictments and that all officers involved are on leave without pay. You can't do that, ladies and gentlemen. You got to do it better than everybody else. Next, this day in legal history, on March 10th, 1969, James Earl Ray was sentenced to 99 years in prison for the murder of civil rights leader Martin Luther King Jr. Now, Ray died in 1998. He was still seeking a retrial of his case. Now, on December 9th, 1999, a Memphis jury handed down a verdict agreeing with the King family that the 1968 assassination of the civil rights leader was in fact a conspiracy rather than the act of a lone gunman. And on March 10th, 1922, Mahatma Gandhi was arrested and charged with sedition for leading a campaign of mass civil disobedience against the British in India. He was then convicted and sentenced to 6 years in prison. After his release, Gandhi continued to build the Indian unity and use civil disobedience and non-cooperation to oppose British rule in his country, ultimately culminating in the Salt March of 1930 and the eventual Indian independence in 1947. And on March 10th, 1913, the Chicago Crime Commission released its first report naming over 28 underworld figures as public enemies, including Al Capone. Obviously, that marked a significant effort to publicly identify and combat organized crime in Chicago. A little public shame and humiliation goes a long way. Next on the docket, our dumb criminal of the day. A woman was recently arrested in Florida after attacking a man with a can of Pringles and possibly causing him permanent disfigurement. Shanika Sadal stands accused of one count of aggravated battery, according to the Orange County Sheriff's Office. The incident occurred last Thursday at a 7-Eleven in Orlando. A deputy arrived in response to a call about a physical fight at the convenience store. The victim, a man, told the deputy that a male approached him and made a comment to him about his truck. Then, inside the store, the victim asked the defendant if she was with the man who had inquired about the car. Anyway, somewhat abruptly, the narrative of the account turns to violence. The victim stated that Shanika eventually struck him in the eye with a Pringles chip can and took off running, according to the arrest affidavit. And while speaking with the victim, the officers observed that the victim had a significant cut on his right eyebrow and below his eye, causing him to bleed. The cut looked significant and appeared that it would actually leave a scar and permanent disfigurement. Guess what? Law enforcement ultimately caught up with Sadira. After the victim identified her as the alleged culprit, she was detained and brought back to the scene. The officers asked Shakira what happened, and she advised the officers that while inside the 7-Eleven, the victim was rude and said something to her disrespectful. Shakira said that the victim called her something that rhymes with punt, and then Shanika admitted that due to the victim being rude, that's when she hit him. The man who was attacked, however, said he wasn't being rude, and the 7-Eleven employee apparently vouched for the victim's version of the events. So there you go, Miss Shanika. Pringles are made for eating, not slamming them into people's eyes. It is assault, and when you have permanent disfigurement, it's a felony as well. So, Miss Shanika, you are felony dumb and our dumb criminal of the day. All right, that's all we have for you today, ladies and gentlemen. I hope you enjoyed the show. Have a wonderful evening. We'll see you tomorrow. And remember, the Constitution matters.